A very good morning to one and all present on this virtual platform. At GLS University's Faculty of Commerce, SMPIC, it has been our constant endeavor to nurture young minds and inculcate new thoughts and ideas. What better than making this millennial generation aware about the recent legal provisions? With the motto of molding minds and shaping careers, we begin with a lecture series, Academics and Beyond, whereby we invite subject specific experts to talk to our students about the contemporary issues in various areas. With this thought in mind, we thought of including the most important topic of your corporate law subject and syllabus, the Negotiable Instruments Act. But before I invite the speaker of the day, let me invite our prolific and dynamic Dean, Dr. M.E. Jokhi sir, to share his views about why a lecture series of this magnitude for our final year BCom honors batch. Over to you, Jokhi sir.
Thank you, Bimal sir. Good morning, Advocate Nisarg Trivedi, resource person of the day, coordinator of today's session, Dr. Bimal Solanki, Dr. Keyur Vora, and dear students. I endorse what Bimal sir mentioned, that at GLS University Faculty of Commerce SMPIC, it has been our constant endeavor to provide an ideal and a creative learning environment. And on behalf of GLS University Faculty of Commerce, I would extend sincere gratitude to the vibrant and dynamic speaker, Advocate Nisarg Trivedi, for sparing his valuable time to conduct a session on a very relevant topic of Negotiable Instrument Act for our students. Dr. Bimal Solanki will formally introduce Advocate Nisarg Trivedi, but at this moment, let me take the privilege of mentioning that today we are extremely fortunate on two counts. First, it is our Gujarat Law Society's establishment day. So wishing happy birthday to Gujarat Law Society and GLS family members. And today's resource person, Advocate Nisarg Trivedi, is also our alumni and GLS family member. Negotiable instruments, again mentioned by Dr. Bimal sir, are regarded as essential elements in the modern business world, and I am 100% sure today that our students are going to have an enriching session. Acknowledge and appreciate efforts of Dr. Bimal Solanki for the wonderful coordination of today's session. Thank you so much, Bimal sir.
Thank you so much, Jokhi sir. We have with us Mr. Nisarg Trivedi today. And let me take this opportunity to introduce the young, dynamic, and very successful lawyer, Mr. Nisarg Trivedi. As far as his educational qualification goes, apart from all the regular degrees, he has a diploma from Regent Business School, RBS, London, England, UK in 2005. He has a diploma from College of Lake County, CLC, Illinois, USA, securing A+ grade. He was an article clerk, solicitor, Bombay Incorporated by Law Society. Apart from that, as far as the working experience goes, he has worked with Chase Bank, that is JP Morgan Group, Chicago, Illinois, USA as a supervisor. He has assisted Mr. Tushar Mehta, Additional Advocate General, High Court of Gujarat. He is assisting Trivedi's Law Office and Associates, that is Advocate, Solicitors and Notary, formerly known as the Law Office and Associates. He is the managing partner at Trivedi's Law Office and Associates, Ahmedabad since 2013. As far as some other introduction goes, Mr. Nisarg has been a part of many TV shows as an expert panelist on regional and national TV channels. And last but not the least, I would like to tell that Nisarg is an SMP graduate from the year 2005 batch. So Thank you very much, Nisarg, for being with us and sparing your valuable time. The session is all yours.
Thank you so much, sir. I am deeply grateful to Dr. Solanki for giving us such a wonderful introduction of mine, and I stand humble. Thank you so much, sir. Well, students, talking about whatever is happening in the business world, it was all forecasted and foreseen when we were ruled by a superior ruling authority. As you all know, we got our independence on 15th August 1947, but there are n number of laws with very few amendments, alterations, and changes which are still in existence in India. When we were ruled by the superior ruling authority, we were a part of the colonial British rule. So one of those specific glaring act we shall be discussing, and the provisions and the ingredients and all the intricacies and the details thereon. So what happened is that way back in the early 19th century, a law comes to be an enacted one. Way back in the year 1881. And when it was enacted, after four successive redrafts, it all started. So it all started that this law, which we are going to discuss today, was first introduced by the Third Law Commission of India way back in December 1867. So which is around nearly 140 years plus. So this all laws are century old laws, but very few amendments. Because if we talk about the future which they could foresee of the cashless transaction which we are now using, it was forecasted back then, because cashless transactions by and within the business community in the world, it was decided back then in 1867 when the first draft was introduced by the Third Law Commission. Subsequently, there were numerous deviations within this English law, and there were n number of objections. So it was redrafted again after a decade, that is 1877. And subsequently, what happens is there was a lot of criticism at that time by the local chamber of commerces, by the high courts, by the local governments for the implementation aspect of this law. And subsequently, this bill was revised by a select committee. A committee was selected and they were asked to work upon it. And then subsequently, it was asked to take it further. Thus, as I said, for the fourth time, this draft came to be revised, and a new law by Act 26 of 1881, a new law comes to the implementation aspect. It was enacted on 9th of December 1881, and it was commenced, that is implemented on 1st March 1882. So talking about this law, as I said, this is more than 140-150-year-old law, but it is still in existence with very few amendments, very few details therein. So subsequently, it all talks about the cashless transactions within the business world. As I mentioned, the objections back then were also from the Chamber of Commerce of the concerned union, India. So when the superior ruling authority was ruling us, more than cash, they did focus on various instruments in the business world. Whether we will discuss it in details when I just we progress in the lecture and I share my PPT PowerPoint presentation. But to just to give you an idea about, this was done primarily to encourage the exchange of checks and the culture of usage of checks and the other instruments, and thereby for enhancing the credibility of the instruments, this law was enacted for this very specific purpose. And it also covers a number of instruments such as promissory notes, bills of exchange, hundis, etc., because customary law is also prevalent. So as you all know, customary law જે આપણો હિન્દુસ્તાનનો છે, જે આપણા કસ્ટમ્સ છે, આપણું કલ્ચર છે, that is also to be taken care of. And back then, yes, very much, which is still in existence. So the basic principle which it still relies on is that, as you all know, the first law which was enacted, the first statute or the first codified law which was enacted within the world, the globe, was Magna Carta. It was in Latin language, and it was done in the way back in the year 1215. So 12મી સદીમાં એક કાયદો બને છે મેગ્ના કાર્ટા, and on the base of it, it was done in the Latin language. So the legal principles we still adopt. So nemo that qua non habet, it's the one principle on which this is all relevant on and which it lies on, which means that a person cannot transfer a better title than what he possesses. And that is what the core fundamental principle is all about. And the guidelines and everything is decided by the central bank. So Central Bank of India, meaning the Reserve Bank of India. And they do impose notifications time to time. They do give amendments in the law, amendment by virtue of a notification, and that is how it is decided. To cite a small example, the validity of a bank check till 2012 was 6 months. Then, by virtue of a notification by the central bank, that is Reserve Bank of India, it was reduced to 3 months. So now the validity of a check is of 3 months only. So that is how it goes. So progressing with it, I'll just share the PPT. So it all starts with this aged old law, Negotiable Instruments Act, which was enacted way back in 1881. So what is a negotiable instrument and what does it do? It allows us to do the business in a certain way where we can receive the consideration of the monetary aspect for the services or the good without actually transferring the cash. So as I said, that we are now actually getting into, after 150 odd years, into this cashless thing, but it was already foreseen by our superior ruling authority, the colonial people, when they drafted this law way back around 150 odd years old. So these instruments are freely transferable. There was an ease in doing business because transferring specific amount of cash back then and till today was a difficult aspect if someone is doing business intrastate, interstate, or by and within some business outside the nation. So that was a difficult aspect. Subsequently, the negotiability confers absolute good title. As I rightly said, nemo that non habet. A person cannot transfer better title than what he has. So person receiving the instrument can claim undisputed title, the title which cannot disputed under except specific circumstances. So that is how it was all about. So what is the definition of a negotiable instruments? There are a number of negotiable instruments which is covered under the Act. And as per the definition which is defined under the law, section 2 of the Negotiable Instruments Act, if we peep into it, the negotiable instruments covers promissory notes, bills of exchange, check payable either to the order or the bearer of the check, and n number of instruments are covered by within it. Subsequently, if we go to the deeper aspect of it, the negotiable instruments can be hundis. So hundi is a classic old example of what our culture and our tradition, part of the tradition is. Share warrants, dividend warrants, bankers drafts, circular notes. Circular notes is not much in usage these days, but circular notes were such notes wherein the drawer and the drawer used to do business by selling of goods and services with someone who was residing or was stationed in some foreign country. Like back then, when the British East India Company was established, there were times that when we used to do business with Dutch East India Company, we used to do business with British East India Company, Portuguese East India Company, and back then the circular notes were much in use. There are bearer debentures. Bearer debentures are certain debentures. Chema, there is no recipient name of the bearer. So even the company keeps a record of it without the owner of the title in the name. So by virtue of a possession, it can be transferred. Banker's check, debentures of the Bombay Port Trust. Back then, since there was the port was the one of the only ways to do business, so back then it was done. Railway receipts. So intrastate and interstate transactions were done by railway receipts and delivery orders. So the core concept of this was the flexibility, the negotiability, and therefore this act was introduced, Negotiable Instruments Act. So what are promissory notes? So section 4 of the Negotiable Instruments Act covers it. By definition, it is, in inverted commas, an instrument in writing not being a bank note or a currency note, contained an unconditional undertaking signed by the maker, the one who writes it, to pay a certain sum of money. Promissory notes are the ones who is given by the maker of that note to someone to pay a certain amount of money which he owns or which is a part of his debt, which is also again under this act it has to be covered as legally enforceable debt, or to order of a certain person or to the maker of the instrument. For example, if we see the illustrative part, so I promise to pay the bearer of this promissory note a sum of rupees 100 forms to be the part of a promissory note. And I acknowledge myself to be indebted to be paid in demand for a value received of X amount. That is how it is. So there are two parties, as we all know, which is already mentioned herein. The maker and the payee, both the parties have to be certain in a promissory note. જે આપનાર હોય, આપનાર એટલે કે બનાવનાર હોય, અને જે રિસીવ કરનાર હોય કે જે લેનાર હોય, both the parties are fixed. You cannot negotiate over the name of the parties because then it falls within the definition of legally enforceable debt. In course of a transfer of a promissory note by the payee and others, the parties involved are endorser, the one who endorses it, and endorsee, the one who is on the recipient end. Then comes the bill of exchange. So section 5 defines the bill of exchange. Which says, I want to save the time, I won't read it out of in toto, but just pinpoint few of the issues. So promise or order to pay is not conditional within this section and section 4 again. So it defines the bill of exchange and instrument for writing. So what happens herein is, herein in bills of exchange there are three parties involved. One is the drawer of the instrument, who creates it, who does it, who is duty bound to discharge his liability. So the drawer is the debtor who is supposed to pay off the debts, and the payee, the person whom payment is indeed to be made, એટલે this is more like something related to what we understand in our local language. For convenience, it is more like an hawalo thing. X, Y, and Z. There are three parties involved, where X role is, as it is defined, who makes the order for making the payment. એકનું જે debt involved હોય અને ત્રીજાને જેને મળવાનું હોય. So there are three kinds of parties involved. The fourth part is check. The most widely used method of payment is check and post-dated checks, which are usually and frequently used in business life. So time and again, Supreme Court, which is the superior, which is the apex court within the Union of India, has given n number of judgments stating what is the enforceability, what is the validity of a post-dated check. But a post-dated check given for security holds no good in the eyes of law. But if we talk about any case in detail, like we'll be discussing further the judgments, it is always dependent on a fact, situation, and circumstantial aspect. We'll discuss that once we progress with our legal aspect of it. So post-dated checks are given to provide a certain accommodation to the drawer of the check towards discharge of the liability which has accrued or which is about to accrue. So that is how it becomes important. So chapter 17 contains section 138 to section 142. I'm sorry, there is some section 148, which was recently introduced. So first time an amendment was done by Act 66 of 1988, and it came with effect from 29th of March 1989, which says in chapter 17 section 138 to 142 back then were introduced, and subsequently 143 to 148 were introduced as the need accrued time and again as there were changes in the business transactions. And section 143, 144, 145, 146, 147, and 148, they were introduced later on after 1990s to bring on a more credibility and usability for the purpose of the usage of the promissory instrument, the promissory negotiable instrument, and for the right adjudication of the case of the trial in hand. And therefore, it is an established principle that any party should not suffer due to the non-payment of the money, because entire purpose of business or the transaction by selling goods and services may go infructuous if it is done so. And then section 6 of the Negotiable Instrument Act is there, which defines check. What is a check? It says check is a bill of exchange drawn on a specified banker and not expressed to be payable otherwise than on his demand, and it includes electronic image of a transcribed check and the check in the electronic form. So that is what it is defined. And explanation 1 further defines check in electronic form, a truncated check, and the clearing house. What does it mean? Digital signature, computer resource, electronic form, and electronic signature. So what is dishonor of check? So dishonor of check means it's a condition in which the bank refuses to pay the amount of check to the payee due to n number of reasons as specified, and by the guidance of RBI, there are n number of reasons wherein payment stopped by the drawer can be one of the this thing. Insufficiency of the funds in the account, bank account closed can be an account, can be a reason. So there are n number of reasons specified thereon. So when a check is dishonored. Subsequently, the drawee bank issues a check return memo, which is in a prescribed format as decided by the central bank, to the payee banker specifying the reason of the dishonor. So there are n number of around uh, 15, 20 odd reasons. So whatever reason is there, they do a tick on it and they do send it across. And the marginal note of 138 of the Negotiable Instruments Act explicitly defines the reason for dishonor of checks being insufficiency of funds, etc., of the funds in the account. So, Section 138 describes the dishonor of the check for insufficiency, etc., of funds in the account. When any person is duty bound to pay to that another person the part of the debt which can be whole, in toto, part of the debt, or any debt or any other liability or debt, and it is returned unpaid by the bank for whatever reason it can be. It can be if it is insufficient to honor the check that exceeds the amount of arrangement done by and between the party, or such person shall be deemed fit to have committed an offense without prejudice to any other provisions of this act. And this is a penal offense wherein 2 years of imprisonment is there, which may extend to the twice the amount of the check if the dishonored instrument, that is the check, is of 1 rupee. So the court may extend it to 2 years, and or with the fine, which is double. So in this case it would become 2 rupees, or with both, as it may deem fit to the Honorable Judicial Magistrate First Class, the first trial court which conducts the trial. Provided that nothing contained in this section shall apply unless there are certain exceptions. Number 1, check has been presented within a period of 6 months. So as I said, till 2012, in the act, as per the notification and guidelines by the central bank, that is RBI, the validity of the instrument, the check, was of 6 months, which was subsequently, since 2012, from 2012 rather, was reduced to 3 months. And within that stipulated time frame, it is to be deposited within 3 months. And if the party does not do so, it is considered a stale check. And stale check is the word or the nomenclature used by the RBI. The payee has to send a demand notice, which is again specified in the statute. So this is known as a statutory legal notice, which જે સ્ટેચ્યુટમાં અંદર નક્કી કરેલું છે એ પ્રમાણે the પ્રક્રિયા, the process. So within 30 days, the person who is in receipt of the check return memo by his bank or the financial institution is supposed to send a statutory legal notice as defined in the statute within a period of 30 days as per section 138 of the Negotiable Instruments Act 1881. એ 30 દિવસની અંદર એને ડિમાન્ડ નોટિસ મોકલવી પડે to the drawer of the check to make good the payment on receipt of the notice or on receipt of the information, as the law says. And he is granted 15 days. If we can see subsection C, subclause C on your screen, in 15 days he has to make good the payment or send a reply, though reply is not mandatory. In 15 days, the party receiving the notice who has issued the check is supposed to make good the payment or do that. Now, if he doesn't do so, there is a strict definition to be followed, meaning legally enforceable debt or any other liability, which I have already explained in the explanation. Debt or any other liability means legally enforceable debt એટલે કે કાયદેસરનું લેણું. what we understand in our graduation, આપણા બેચલર ઓફ કોમર્સમાં તમે લોકોને આવતું હશે જે. So legally enforceable debt, કાયદેસરનું લેણું, not only the part of લેણું કે મારે આપવાના છે ને એને લેવાના છે ને એને આપવાના છે ને આને લેવાના છે. No, it has to be it has to fall within this definition of this statute, and therefore it becomes legally enforceable debt. કાયદેસરનું લેણું હોવું જોઈએ. Only then it is covered, or any other liability. So any other liability, again, બહુ wide definition થઈ જાય છે. That is how it is. Now we'll go on to the ingredients required for complying with section 138, which are: a person drawn a check for payment of money to any other for the discharge of any debt or liability, which I just explained. Okay, it is towards a debt or a liability. Like many of you must have observed in foreign nations, because checks are a form of negotiable instruments, so it can be replaced by cash. So like you must have observed in foreign nations, even petrol pump transactions are done by a bank check, though that practice is not common within our Union of India, because if that is dishonored, there is a process to be followed, there is a procedure to be adopted, and it becomes lengthy and it is bit time taking. And for discharge of a small liability or a small debt, that may or may not construe to be a wise decision, and therefore checks are not exchanged, right, from small transactions at a grocery shop or petrol pump. And check has to be presented within 3 years. So as I rightly mentioned, 3 months, I'm sorry, 2012 ના જે RBI ના notification પ્રમાણે. And if it is returned by the bank unpaid due to insufficiency of fund or any other reason, or exceed the arrangement, it comes back with a check return memo by the bank. And within 30 days, a notice is to be given. I'm sorry, this mentions 15 days, but actually it is 13 days, as I explained you all. Upparamna. So within 30 days, a statutory legal notice is to be complied with. And 15 days time is given to the other side to make good the payment. And if it is not done, again within a period from the date of the receipt of the notice, 15 days is given, and post expiry of that 15 days, 30 more days are given. One can initiate and file a criminal complaint under section 138, as well as an examination in chief under section 142 before the concerned judicial magistrate first class of the concerned taluka. So there are 4 hierarchies of courts within the Union of India. There are taluka level courts, wherein criminal matters hoy to judicial magistrate first class takes care, or civil matters hoy to civil judge JD junior division. Then comes district courts, criminal law to in this case sessions court, which I'll just explain again. Then would come high courts, then would come the apex court, that is Supreme Court of India. That is how it is. So post filing, the complainant or his authorized agent. Who can be an authorized agent? Because all businesses are not run by the proprietors or the partners or the directors or the managing directors by themselves only. So many a times there is an authority letter to be given, or a power of attorney is given, and that becomes an authorized agent, because the principle of principal and agent applies to this. Should appear in the witness box. So once that complaint is filed, he or his agent has to appear in the witness box, provide with the relevant details for filing of the case. There could be 138 no case line. I'll show you an example as well as we progress. So that has all the basic intricacies or the details in a nutshell. who had issued the check, which was the bank or the financial institution which was involved, what is the amount involved, when was the instrument dishonored, when was it the return memo was given by the bank, when was the legal notice sent, on which date, by registered e-post, which is mandatory. 15 days ક્યારે પૂરા થાય છે. So within 30 days, within the time period, when is it getting over and when is this complaint filed? So this all aspect is to be ascertained by the judicial magistrate first class, and therefore the complainant or the authorized agent has to enter the witness box. If the court is satisfied, then it shall go ahead and issue a summons. Summons, in simple language, it's a notice to the accused to appear before the court of law concerned. Accused એટલે કે આરોપી in Gujarati language. He is summoned by the court that you remain present on X date at X time in X court for so and so case filed by so and so toward discharge of your liability. અને આની જે આખું હોય એનું negotiable instruments act court number so and so માં આખું describe કરીને એનું summons છે એવું. But there is a provision as well. There are n number of cases wherein even after the summons is issued, the drawer does not appear. જેણે check આપ્યો he never appears. So there is a provision available, and wherein a non-bailable warrant is issued for the first time. Non-bailable warrant એટલે being જામીન લાયક warrant. જે warrant એને issue થાય અને ત્યારે if the accused or the drawer appears, then after the court will go to the furtherance, rather it will proceed. And there are times when the accused or the drawer may not even appear, even after issuance of non-bailable warrant. In that scenario, a bailable warrant is issued, and with the help of the concerned local police officials, the police personnel goes to that accused's place of business or residence and serves him the copy of the bailable warrant. And then the party appears before the concerned court of law and has to furnish a bail bond. And this bail bond is to assure that his presence shall be for the trial. Thereafter, what happens is that the plea of the accused is recorded, wherein he has two options: to plead guilty or to plead not guilty. In case if he pleads guilty, the court will pose the matter directly for the punishment. So, my friends, as we all know, that once a case or a matter accrues or arises, it is all dependent on the facts, the situation, and the circumstances concerned thereon. And only by getting into the intricacies and appreciating it with the concerned law and appreciating it with the judgments of the Honorable Supreme Court and the concerned High Courts, the judges, as in the magistrate, from the magistrate till the Honorable Justices of the Supreme Court, they shall be in a good position to ascertain them and pass an order thereon. So if the accused denies the charges, he shall be served with the copy of the complaint. In case he pleads not guilty, in that case, the complainant has to present his evidence by way of an affidavit, which I said, 1 for section 142, along with all the original documents, right from if there is a transaction bind between them, as in the bills of exchange, bills, promissory note, what all supporting documents, check, written memo, legal notice, registered post, everything is to be placed on record. His income tax return, if concerned, everything is to be placed on record. And thereafter, the complainant will be cross-examined by the accused or his counsel. And herein, what happens is that the cross-examination is done like what you all friends must have seen in a number of movies, right? From on the lighter side, Jolly LLB 1 2, क्योंकि मैं झूठ नहीं बोलता. So there is a witness box wherein first the complainant is supposed to step in, is supposed to swear by on oath, and then there are questions asked by the accused or his counsel or his lawyer or the representative, and that is how it is done. So that is the process. The accused will be given an opportunity to lead his evidence. And on affording him an opportunity to submit his document in support of the case, so accused has to present all the documents of his defense to the concerned court as well as the witnesses in his support. And accused and his witnesses will also cross-examined by the complainant as and when the stage accrues. There is a last stage of the proceeding. The last stage of the proceeding is that after perusing all the documents placed on record, after arguments by both the sides of the lawyers, after getting into the legal aspect of it, after getting into the law, after appreciating the right sections, after getting into the judgments of by the Honorable High Courts and Supreme Court, the court shall pass a judgment. Here there are two options. The judgment which is passed, wherein the accused can be acquitted. Acquitted, as you must have heard this phrase in the movies, by Ijjat Bari Kiya. So that is what acquittal means. The matter comes to an end and he is acquitted. And post acquittal, the complainant has a right to file an appeal before the concerned district court, which in criminal cases is a sessions court, as you can see on your screen, last line. And post sessions court, whoever wins can go or approach the Honorable High Court concerned and subsequently Supreme Court. So that is how it is. So what is the main objective of Section 138A? The main objective is to promote the efficiency of the banking transactions and the operations in order to ensure the credibility of the transactions through the check, and this has been clearly defined in the case law by the Honorable Supreme Court in Modi Cements Limited versus Kuchil Kumar Nandi case. So this act was enacted specifically and thereof incorporated with a specific intent and an object by making a special provision of incorporating a strict liability so far as the negotiable instrument is concerned, and to also to simplify the activities of trade and commerce within the business community and to give it a boost which would have been converted into money and easily be passable from one person to another, and therefore it's called a negotiable instrument by the definition. There is another famous case, Dalmia Cement versus Galaxy Traders and Agencies. In this case, the ratio decidendi as laid down by the Honorable Court is that negotiable instruments are the instruments of credit being convertible on account of the legality of being negotiated and easily transferable. X થી Y ne, they can be easily transferable, and the law approves of it. And to attain the objective of the act, the legislature has, in its wisdom, thought it proper to make such provisions in the act by conferring such privileges to the mercantile instruments considered under it, and provide special penalties and procedure in case the obligations are not fulfilled or not discharged. Now, in Vinod Shivappa and Nanda Belinga case, it is clearly stated that the purpose of Section 138 of the Negotiable Instruments Act 1881 is not to protect unscrupulous drawers who never intended to honor the checks issued by them, it being a part of their modus operandi to punish the unscrupulous persons, which is clearly established. Now we go on to the scope. What is generally, when we argue it in the higher courts, it is all dependent on law more. In the lower courts, it is more dependent on facts. High court also, facts are very important, but law is equally important everywhere. But here the focus on law is a bit more. So the scope, the size, the ambit of the law is also to be appreciated. So Section 138 creates a statutory offense. So what is a statutory offense? Statutory offense is an offense which is covered under the statute. Statute એટલે કાયદામાં જે કવર થતો હોય. In matter of dishonor of checks on the grounds of insufficiency of fund, payment stopped by the drawer, etc. In the account maintained by the person with the banker and exceeds the amount of arrangement to be paid from that account by the agreement made with that bank as mentioned in that. There can be n number of reasons, as I rightly said, around 50, 20 odd reasons. Signature does not match, payment stopped by the drawer, insufficient funds, account closed by the drawer, etc., 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 n number of reasons. But the instrument subsequently is dishonored. The liability is dishonored for the want of funds. The payment is not made by the drawer, in spite of the fact of it is mentioned in the legal statutory notice of demand. And therefore, it is considered to be a criminal offense. Though it's a summons tribal offense, but it's a criminal offense. There are two types of offenses, cases rather. Summons tribal and warrant tribal. So this falls within the definition of summons tribal cases. Wherein, as I explained you previously, a summons is sent, the parties may adhere, or in few cases they do not adhere to it, then non-bailable warrant is issued, then subsequently bailable warrant is issued, then non-bailable warrant is issued, and that is how it is. But my friends, in criminal law, the most important aspect, again in the Latin language, is mens rea. Mens rea means an intention. Hetu. Mens rea is very essential component of a crime, but in dishonor of check is a criminal offense, but here no need of proving a mens rea. It is not an essential thing. Construction of a strict liability in this section is an effective measure to prevent usual carelessness and change of attitude of the drawers in discharge of the debt. That is on this. Liability. There are two liabilities which accrues when a check is dishonored. And since there is an accruement of two liabilities, there are two legal options available. Number one is the civil liability. So civil liability is also covered under Negotiable Instruments Act. So as I cited an example that 1 rupee instrument bounce હોય ને કોર્ટ એને ફાઇન ઇમ્પોઝ કરે 2 રૂપિયાનો, double the fine, that is covered under civil liability as well. And the payee can also file a suit under Order 37 of the Civil Procedure Code for recovery proceedings. then the judgments in his favor of the payee, then the drawer should pay the amount as mentioned in the concerned court order. Then comes the criminal liability. Section 138 provides the punishment for 2 years of imprisonment, and the drawer can also be prosecuted under section 420 and 417 of the Indian Penal Code 1860, which is again a superior ruling authority when ruling us for the purpose of cheating. This law was introduced. This is the first statute Lord Babington Macaulay introduced in 1860. Unfortunately, he was not alive to see this law being implemented. Now we get on to the penalty aspect. As I already said, there are two remedies available in civil law and in criminal law. So, under the Code of Civil Procedure 1908, before the concerned court, a suit for recovery is to be filed, recovery suit, to procure the amount back. And in criminal, 138 is also covered under it, wherein imprisonment can be extended up to 2 years and fine, which can be double. And also by filing a criminal complaint against the accused person. So these are the penalties. There are recent Supreme Court judgments. So when we first get into Dayavati and Yogesh Kumar case, which was decided in 2017, took an account of question whether an offense under 138 is criminally compoundable case could be settled by mediation. Mediation એટલે મધ્યસ્થી. So in India, Section 89 of the Civil Procedure Code 1908 specifically regulates the alternative dispute resolutions, the way in which the matters or the cases can be settled outside the court. But it refers to court referred mediations or arbitration or lok adalat, and these are the conciliation is also formed to be a part of it. So these are the four alternative dispute resolutions methods. The court has even though an express statutory provision enabling the criminal court to refer the complainant and the accused person to alternative dispute resolution has not been specifically provided by the legislature. The Code of Criminal Procedure Code does not permit and recognize settlement without stipulating or restricting the process by which it may be reached. But it may not operate as a bar because alternative dispute mechanisms or ADR, alternative dispute resolutions, are recognized under the statute which I just said for settlement of the disputes, more specifically as covered under section 320 of the Criminal Procedure Code 1973. It is also stated that proceedings under 138 of the Act is distinct from criminal cases and are really in nature of a civil wrong, which has been given criminal overtones. We get into the meters and the instruments limited versus Kanchan Mehta case. So here the court has laid emphasis on chapter 17 of the Act, which covers 138. And from the following aspects emerge, second para, and I have also reproduced 18/1. Offenses under 138 is primarily a civil wrong. Burden of proof is on accused in view of the presumption under section 139, but the standard of proof is preponderance of probabilities. The same has to be normally tried summarily as per the provisions of summary trial under CRPC, but with such variation as may be appropriate to proceedings under chapter 17 of the Act. Thus read, principle of 258 of the CRPC shall apply, and the court can close the proceedings and discharge the accused on satisfaction that the check amount with the assessed cost and interest, if paid, there is no reason to proceed with the punitive aspect. To save time, we may not get into the intricacies of the judgment, but we'll get into the recent amendment. So there was a case of Dashar Singh Roop Singh, and which decided the jurisdiction of the negotiable instruments cases, and post that all the cases were transferred to the person who issued the check within that local jurisdiction, and subsequently Supreme Court settled it. And there is also a recent amendment in the year 2018, to be precise 1st September, wherein any person who files a criminal matter under section 138 of the Negotiable Instruments Act 1881 before the concerned judicial magistrate first class, he has a right, or he can make an application to demand that interim compensation of 20% from the concerned court, and wherein in turn the powers are given to the concerned district magistrate, who happens to be the collector, અને એ ફાઇન રકમ વસૂલ કરવાનું પ્રોસિજર કરી શકો. So that is how it is, which is a recent amendment, which is welcomed by various chambers of commerce, and much needed change as per the business community. So documents to be annexed. 138 ની કમ્પ્લેનમાં શું શું હોઈ શકે ને શું શું હોવું જોઈએ? પરફોર્મા હોવો જોઈએ, ઓરિજિનલ ચેક હોવું જોઈએ, ઓરિજિનલ ચેક રિટર્ન મેમો હોવો જોઈએ, કોપી ઓફ ધ લીગલ નોટિસ હોવી જોઈએ, ઓરિજિનલ પોસ્ટલ સ્લિપ હોવી જોઈએ, 142 નું જે એક્ઝામિનેશન ઇન ચીફ હોય એમાં બધું જ હોવું જોઈએ. કમ્પ્લેન્ટ તો આવી ગઈ, but these are the annexed documents which form to be a part of the proceedings in total. Proof for the lawful liability હોવી જોઈએ, 7 નંબર 8 નંબરમાં ઓથોરિટી પાવર ઓફ એટર્ની જે બી આપ્યું હોય બોર્ડ રેઝોલ્યુશન એ હોવું જોઈએ, એફિડેવિટ હોવી જોઈએ, સોગંદનામું, and evidence ની એફિડેવિટ હોવી જોઈએ 300 of 200 of CRPC પ્રમાણે. Okay. So this is what it covers by and large, Negotiable Instruments Act. So to promote the harmony, promote the less of debts within the business community, and for the smoothness in transactions, જે આપણે ગુજરાતીમાં કહીએ ને ટ્રાન્ઝેક્શન્સની મિઠાસ, ધંધાની મિઠાસ, એના માટે this act was enacted. We can imagine the future which our forefathers did foresee nearly 200 years back. And that is what this law is all about. And to smoothen the processes by and between the business transactions. Thank you so much for being a wonderful audience.
Thank you, Nisarg. But there are quite a few. There's one very important, very interesting question. That
Yes, sir.
sir, do you believe that checks will be a history in the times to come, or how do you see the Negotiable Instruments Act 20 years down the line?
Well, see, as and when the time changes, the needs changes of the business world, there are amendments in law. So as you all know, to pass a certain law or bring in an amendment, there is a process. First, the bill is presented in the lower house, which is known as Lok Sabha, then subsequently sent to the upper house, which is known as Rajya Sabha, and then it is sent for President's Note, which is the first citizen of the Union in India. અને એના પછી એક એમેન્ડમેન્ટ આપતું હોય, જેમ જેમ સમય સંજોગ પરિસ્થિતિ બદલાય એ પ્રમાણે હોય. That is how it is. If you ask me personally, I won't be in a good position to comment, but I think the way the business world is taking shape and taking place, with the usage of the right usage, I'll use the word, of technology, the world is a smaller place we live in. Because when I was young, interacting with someone, we had pen friends, and Bimal sir shall also agree to it. I had my few friends in Japan and England when I was very young. We used to write letters, and then as technology evolved, after this 2000 Y2K evolution, emails came. There was much usage of technology around, and right now we are fortunate enough कि आपण रिक्षावाળા પણ પેટીએમ થી ને ગૂગલ પે થી ઓનલાઈન પૈસા લે છે. So what better world can we expect? That's about it.
Thank you so much. So
Thank
it was actually very interesting, Nisar, and I'm sure your industry and legal intelligence and command over the subject has actually helped us, uh, help me and the students understand the this very interesting topic in a better way. The intricacies of the legal aspects of negotiable instrument was actually a treat coming directly from the horse's mouth. So thank you very much. And on behalf of GLS University Faculty of Commerce SMP, I extend a big thank you. And we hope for many more future conversations with our students, probably in times to come, in face-to-face kind of interactions, not online. So we are very shortly, probably when we'll be going offline totally, we would love to see you again to interact with our students. Thank you very much, Nisar, for
Thank
your
you so much,
valuable
sir.
time.
Thank you
It
so much,
was
sir. I stand grateful and I'm obliged, sir. Thank you so much.
it was really amazing session. Thank you very much.
Thank you, sir.
Thank you. Thank you
Good
so
day,
much.
sir. Good day, Kyoor, sir. Thank you.